I muted you on accident.
Mm-hmm. All right, ladies and gentlemen, I'm presuming people are able to hear me. And from my screen, there we go. People are able to see me. Before the court this morning is a motion for emergency hearing, pardon me, in the matter of James C. George as petitioner versus Aisha Me Abdullah as respondent. Who is here representing James C. George? Anybody? Nobody. Who is here representing Aisha Me Abdullah?
Judge, that's for 10. This one is Dean Hurd versus RTS Warren. The one you just mentioned is for 10 a.m.
10 a.m. Nobody tells
Yes.
me these things. Okay. Custody issue, is that right?
Yes, correct.
And as far as you know, everybody's here and ready to go.
Yes. Just let them in from the waiting room.
Right. I'm going to refresh in my cup of coffee. I'll be back in about 5 minutes.
Okay.
This is Matthew Robbins. I'll be presiding in the business before the court. I don't know who's out there, so whoever's there, would you please announce yourself and let me know who's here?
Good morning, Your Honor. Otanya Clark, the attorney for the petitioner in this emergency matter. The petitioner is Mr. James George. I represent Mr. George. Ms. Abdullah is also present, pro se, and she is the respondent mother in this matter.
All right, so both parties are here.
Yes, Your Honor.
You're on behalf of Mr. George, and Ms. Abdullah acting on behalf of herself. She's present.
Yes.
Okay. All right. I've read your motion for emergency hearing multiple times. There are some questions I have about it. Naturally, you should expect that. Excuse me. I'm recovering from no telling what. Before I get to the merits of the petition, anything you want to tell me, counsel, sort of as a preliminary that would help us lead into this?
Just some brief preliminary matters, Your Honor. One, we're here mainly out of concern for a 17-year-old.
Right.
And I understand that these matters, particularly during the holiday season, there were some information that was not privy to us to present to the court because of the timing of what has happened here. But it was very important to file the emergency motion because of the injuries that were sustained to the 17-year-old. And we had a great concern with regard to the supervision issues as well. I don't know whether or not the respondent plans to call the 17-year-old, but I would just simply request if the 17-year-old is called, that the court have a meeting with the 17-year-old in a breakout room out of the presence of both of the parties, if that is necessary. We would like to proceed with just giving a summary first without a formal hearing in terms of a pretrial approach. But if the court is so inclined to do that, we would respectfully request that. And I don't know that there is an objection from the parties with respect to that.
Well, I think it's appropriate that you advise the court of that possibility. There are matters in the motion itself that are not clear to me. And so I need some clarification.
Sure.
A little bit. So, counsel, I'm going to reach out to you and I'll address what has jumped off the page for me.
Certainly.
In the petition, in the motion, in paragraph 1, you have referred to this as a petition for modification of child custody. Is that actually what we're dealing with, is a modification of child custody?
Part of paragraph 1, Your Honor, is laying out those initial paragraphs, laying out a procedural history with respect to this particular case or situation. So there is a pending petition for modification that will be heard before Judge Hyrick on the 16th. We're just giving the court the benefit of knowing what has been done thus far first. But what is before the court today in terms of the court's determination is the emergency motion.
So you've cleared, that's good. You've addressed something that I picked up on, but wasn't clear why I'm doing this. Okay. So I'm not doing a petition for modification. Judge Heydrich, you said
it is my understanding. It is before Judge Heydrich.
Okay, don't confuse me with too many facts. Further down in paragraph 4, you make a direction about seeking judicial direction regarding the filing of Tennessee court documents. What Tennessee court documents?
Those are documents that will also be a part of what Judge Heydrich would consider. So in the modification, an issue with regard to domestication.
Okay. But
What the court will be focused on today, we gave the court a procedural history just in case the court needed to know what had been filed prior to the emergency motion. But what is before the court today in terms of focusing on what we wanted to speak to the court about today would be paragraphs 5 through 11 regarding the incident with the 17-year-old and his 24-year-old brother. That was a key issue or incident that brought us to court today for an emergency motion. Right now, our understanding is the existing parenting plan has mom indicated as the primary custodian and dad the secondary custodian, with regular visitation on the first and third weekends. And they alternate Christmas breaks, with dad having odd and mom having even. So it is our understanding that right now it would be mom's time. Well, during mom's parenting time, the child was left with his 24-year-old brother while mom was in Colorado. An incident took place between those brothers that resulted in the 17-year-old having swollen eye, blood, police being called over, and a gun being pointed at the 24-year-old. At the 17-year-old. The 24-year-old brother pointed the gun at the 17-year-old. And that prompted the filing of this particular emergency order for a couple of reasons. Mom is in Colorado while the 17-year-old is being supervised, quote unquote, by a 24-year-old. Two, the injuries that was sustained by the 17-year-old, with the police being called out, him having a swollen eye, blood and what have you because of a fight between the brothers, and a gun being pointed out to him. And three, some significant strong questions with regard to inadequate supervision, tardiness in school with regard to the 17-year-old being monitored by his 24-year-old brother, disciplinary actions, lack of food, and ultimately this incident that happened just right before the holidays that we were advised about around December 20th, 23rd, when we filed this motion. And so while those other issues are on the calendar to be heard by Judge Heydrich on January 16th, we thought that it would be an urgent issue to bring before the court prior to January 16th, because we have this 17-year-old who's not being adequately supervised, who's been exposed to harm and violence and mistreatment and abuse. And we believe that there should be an emergency temporary change with regard to who the primary custodian is until an additional order has been issued by the judge who has the case now, in a nutshell.
Excuse me, Your Honor. The attorney has made an opening statement. Will I be able to have an opening statement as well?
Yes, ma'am.
Thank you.
And respectfully, we were just summarizing. It was not a formal opening, but we certainly don't object to the respondent having.
It's just a matter of semantics. If he wants to talk to the court, now's her chance to do it.
Absolutely.
Address the court, madam.
Yes, I would. My son was born on October 24th to 2007. And from that time to August 3rd, 2016, Mr. James George voluntarily did not participate in his visitation. During that time, I had filed a petition in Tennessee. And during those hearings, my son was abused during those hearings. And we had a permanent restraining order against Mr. George. During that, from August,
Your Honor, we would respectfully object with regard to the relevance
3rd,
of this matter.
2016
Right,
until November.
Wait, just a minute. One of the problems with Zoom hearings is we forget that we're in court, and we are in court. And I will run this hearing as if we were in court. I expect everyone to act as if they were in court with professionalism. And Madam, Ms. Abdullah, if you're not a lawyer, that doesn't mean that you should not, or you cannot act with professionalism. In that respect, when one person objects to something the other person is saying, the person who was talking must stop talking.
Understood, sir.
So the court can hear what the objection is. I
Understood.
cannot hear when both of you talk at the same time. I will give you your opportunity to speak, and I will give the attorney her opportunity to respond. But we are in court. Even though you're someplace, I'm someplace, the attorney someplace else, let's understand what we're doing and where we are. All right, Ms. Abdullah, you can proceed. And I didn't catch, Madam Attorney, what your objection was. So state your objection.
Your Honor, we were simply objecting from a relevance perspective. We are here for an emergency.
And I didn't catch, Madam Attorney, what your objection was. So state your objection.
Your Honor, we were simply objecting from a relevance perspective. We are here for an emergency hearing for the event that prompted our emergency filing. It appeared that Ms. Abdullah was going into some discussions about some abuse allegations that took place during prior dealings with regard to the divorce proceedings that were years ago. These parties were divorced in 2011, 2012-ish, and had another proceeding in 2018 in Tennessee. I would just respectfully request that the opening be limited to from a factual basis or presentation basis on those things that we are discussing today, respectfully.
Yes, Your Honor, if you just give me a couple of minutes.
If you'll just give me an answer to interject my response to the objection. My response is, believe it or not, the court feels it has the ability to discern what is relevant and what is not. And while it is proper for either party to object to irrelevant, I really don't give it a lot of weight, because I have the ability to pitch aside that which is of no concern to the matter for which I am here to hear. But I am also wanting or allowing both parties to vent and get it off their chest, and then we'll get down to the legal issues before the court. So I remind both parties, I do not give a lot of weight to irrelevant. I am capable of discerning what is relevant to the matter pending. And also I do recognize that parties, particularly in issues involving divorce, custody, they become personal between the parties. And sometimes I allow it because it gives them a chance to vent, which has no legal basis, but I feel it's good for the system to let parties speak their piece within limitations. At some point, I may just say, I'm tired of listening to it, let's move on. But for the moment, the relevance objection is sustained. It was not relevant. But don't worry about it. I don't pay much attention to it anyway. Having said that, Ms. Abdullah, move on and tell me why you're here.
I am here because I have been raising Zakai for 17 years without any visitation or assistance from James George. We finally got in contact with James George on November 9, 2022. And I had my son to call him for that because he was having knee surgery from a basketball injury. So Mr. George hasn't been a part of his life until November 9th of 2022. Mr. George and I had started up a co-parenting schedule because now my son had met him and wanted to have a relationship with him. We did not go by a visitation plan. He's 16, 17 at this time and was free to go between the homes. We are only 20 minutes away from each other. When I got a promotion of April of this year, April 28th of this year, when I got a promotion, Mr. George and I came up with a visitation because I would be gone for 10 days and I would be home for 4 days. So while I was traveling for work, those 10 days, Mr. George had custody and control of Zakai. When I was home, I would have custody and control over Zakai. I still participated in everything that he was doing. When I gave custody and control of Zakai to Mr. George, that was in April of this year. He had a grade point average of 3.28. He had 0 behavioral issues. He had 0 attendance issues.
Ms. Abdullah, it strikes the court, the thrust of what you're telling me would be more appropriate at a hearing for change of custody, which is not before the court today.
Yes, sir.
I would like to redirect you to the matter which is before the court today, which is a motion for an emergency hearing, as your counsel addresses it, to be granted, quote unquote, primary physical custody.
Yes, sir.
So,
yes, sir. And that's what I'm trying to convey to the court is that while I am in Denver, when I am not in Atlanta, my son is in the custody and control of Mr. James George per our verbal agreement and has been that way for the past 8 months. So when this incident occurred, I was in Denver. He was in the custody and control of Mr. James George. I also had my son for Thanksgiving, took my son on a vacation because I don't celebrate Christmas. And he was in the custody and control of Mr. James George on the day that this incident happened. So I don't understand why I am being sued for custody, for emergency hearing of removal of custody and control of me when he was actually in the custody and control of Mr. James George. That is, I'm sorry I took a long way around, but that is the synopsis.
May I offer clarification, Your Honor?
Yes, ma'am.
Your Honor, the parties have a parenting plan that was established with the divorce decree. The order indicates that her parenting time was during the time of the incident for December 19th. I am aware of no offer of evidence of any oral agreement. It is not my understanding that if it was an oral agreement, and we're not submitting that it was, that would trump or change the order that is before us. The parenting plan was.
Wait. Say that again.
That we're not submitting that there was an oral agreement. We are indicating that there is an order, a parenting plan that was incorporated into an order when they were divorced that indicates that mom's parenting time was during the time period of the incident that led to the filing of the emergency motion that is before the court today. There was an incident, a fight between the brothers on December 19th. Mom, as she's already presented to the court, is in Colorado.
No, you said something that I wanted your clarification.
Sure.
It wasn't clear because I didn't pick on it maybe the way you intended it. I thought you said that the off the record parenting agreement did not trump the court's agreement.
It is my understanding that if there were any agreements, I'm unaware of any oral agreements between the parties. The parties have a parenting plan that they follow, and in accordance to the parenting plan, and in accordance to, and that parenting plan was incorporated as part of the order, that the parenting time for mom was during the time period that the 17-year-old was harmed.
Your Honor, if we're going by the written parenting plan, Mr. George has never ever participated in that visitation plan.
Ms. Carter, hold on, madam. If he hasn't complied with it, you have a remedy. But the fact that he hasn't complied with it doesn't mean there's not an agreement.
Well, I don't want you to say, oh, we have this paper here, so we were supposed to follow this visitation plan, when I have evidence that we have been following the 10-4 visitation plan. We've been following that. He has been in the custody and control of Mr. James George for 8 months.
This is beginning to spin out of control. Let me address the issues that are before the court, so I can make a decision. I don't mind people venting, but I believe some of this is going outside of the scope of what we're here for. I've determined, based upon what the attorney for Mr. George?
Yes, Your Honor.
For Mr. George, that this really isn't, contrary to paragraph 1, what I'm hearing, it really isn't a petition for modification. Judge Heydrich is going to hear that at a later date. Is that a fair statement?
That is a fair statement, Your Honor. We're here for the emergency.
That's the answer. Okay. I wanted to find out what is, and in paragraph 4, I wanted to find out what are these Tennessee court documents? What are they?
The Tennessee court documents was an effort for modification by the parties, but those Tennessee court documents of that order did not modify the parenting time. So they were divorced in Chatham County around 2011, 2012. The court signed a pro-tuck in 2012. And then in 2018, the case was modified in Tennessee. These were parties were in the military, and so there were various states involved in terms of proceedings. We referenced the Tennessee documents because they reference parenting time by just simply stating we won't change the parenting time that was established by the Georgia court. Right, so but it also addressed child support. And so that's why it's a part of our modification with Judge Hyman.
The Georgia courts have addressed parenting time, custody, and the Tennessee court addressed child support.
The Tennessee courts addressed a number of things, alimony, child support, what have you. But in terms of what the court's focus is on, it addressed child support, and parenting time, it just said remained the same.
Which order is the dominant order addressing child custody? The Georgia
I
court?
would say the Savannah order is the dominant order that addresses custody,
And hasn't
and
been,
that is attached. That it is a part of the record as it is.
it hasn't been modified.
It has been modified with respect to other issues
Oh,
pertaining to the
here's my
divorce.
The
Oh.
Chatham County Court addressing child custody is still in existence and has not, as to the issue of custody, has not been modified.
That is my understanding, Your Honor. The Tennessee order actually says in writing, we
Don't
won't.
confuse me with facts
Okay.
that are not relevant. All right. The issue in I've addressed it, but I'm trying to get y'all to move along. All of us
Okay.
to move along, not just y'all, all of us. Paragraph B of your prayers, you wanted to be granted primary physical custody. The term primary is, to me, not a legal term, but I think what you mean is you wanted your client to have sole custody of the 17-year-old on a permanent basis?
On a permanent basis, Your Honor, pending the next order that we get from the other court right now because of what has happened.
Judge Hydrick?
Yes,
Okay.
because of what happened
Okay.
prior.
This event that happened, which prompted this motion, it is serious. Happens in the course of continuing conduct? Does it happen a lot?
With respect to the violence and the gun being pulled out and the police officers coming over, this is my understanding of the first time that this has happened. But there are other challenges that have happened: tardiness in school, being suspended from school, lack of food issues. While mom being in Colorado, being partially supervised by a 24-year-old, it's my understanding the 24-year-old is unemployed.
All right. So the mom is in Colorado.
Yes, Your Honor.
The children, the two boys are also in Colorado.
The two boys are here. Mom is in Colorado, and we got a 17-year-old being supervised by a 24-year-old.
I object, Your Honor. I object because that is
Ms. Abdallah, just wait your turn. I'll give you a chance to respond. Please give the court an opportunity to figure out what's going on so I can better address the issues to be resolved. I will hear from you, but I cannot entertain objections in the middle of a presentation. I will not allow the attorney to interrupt you, nor do I want you to interrupt the attorney. I cannot operate that way. Now, I'm trying to figure out, the mother is in Colorado. Is that correct? Yes or no?
That's my understanding, Your Honor. The mother's in Colorado and
boys,
was there during the incident.
All right. The boys are in Georgia. Yes,
DeKalb. No? Yes.
Okay. The father is where?
Here in Atlanta.
The mother, under a court order, has sole and quote unquote primary physical custody. Is that correct?
Primary physical custody
was awarded by Chatham County.
Awarded by Chatham County.
Okay. The incident complained of in this emergency motion is, while serious, it has not occurred on a regular and recurring basis. Is that correct? Yes or no?
This specific incident, I have no knowledge of it recurring on a regular basis with the police officers coming over and the blood.
The child, the 17-year-old, may have other issues regarding school, whatever they may be.
And discipline with suspension, and there's been lack of food there. But in terms of the police officers and this fight and a gun being pointed, it is my understanding that particular incident is the first.
Okay, now Ms. Abdallah, jump in and tell me what you were going to tell me before I stopped you.
Your Honor, my son is not under the supervision of my 24-year-old. My 24-year-old goes to school. My son is supposed to be under the custody and control as per our agreement with all three of us, Mr. George, myself, and my son. There's a group chat with all three of us talking about what time he should be home for curfew.
Ms. Abdallah, I must caution, interject. You cannot have an oral agreement or an agreement between the three of you.
Well, I'm sorry, sir, but I thought I was co-parenting.
Ms. Abdallah, I'm in the middle of a sentence. I would prefer not to be interrupted. The three of you, or whoever, one of you, two of you, three of you, whatever, the number is irrelevant, are not allowed to adjust the terms of the agreement entered by the court in Chatham County. You cannot make your own agreement. Just a minute, I'm in the middle of a sentence. If it is your purpose to change the terms of that agreement in Chatham County, the proper method is what has been done, the filing of a modification for child support. That's the way it's done. You cannot go off in a corner with Mr. Whatever his name is, Mr. George and the two boys and say, I'm working and you're in school. Let's see if we can amend this to make it so we can all fit. It doesn't work that way. You cannot do that. So whatever the agreement that was entered into by the court in Chatham County, that remains the agreement until it's modified.
Okay, so, Your Honor, I understand that, but I was trying to assist Mr. George in getting his parenting time since he had been absent from his life for 16 years. He came to me with this, okay? If it wasn't for Mr. George with this visitation schedule that we had, while he said, Aisha,
Right.
Go out there, you've had 16 years. I would like at least a year or so to spend time with him. I said, that's fine. And so because I would have moved my children with me if that was the case, or I would have found another job. But because I thought that Mr. George and I were in a positive co-parenting agreement that was based on, I thought was a mature adult conversation, and we had actively started doing that visitation schedule. I had him for Thanksgiving. I told my job I would work for Christmas because we came up with having him for holiday.
Your actions are commendable. They are well-intentioned. The court understands that. And for the good of the family, it was probably the right thing to do is to make those adjustments. The fact remains, however, you cannot unilaterally change a court agreement. I am concerned not about visitation. I am concerned about changing the primary physical custody of the party's minor child, because that's what's before me. The other issues that you seem to be wanting to address can very well be presented before Judge Heydrich on January the 16th regarding custody, visitation, make some adjustments. That's the time to do it, but that's not before me. I'm here to change, quote unquote, primary physical custody of one incident which happened where the 17-year-old was violently hurt. And because of that, the petition seeks to change, quote unquote, primary physical custody. That's all that's before me.
Yes. May I add clarification?
Not visitation, not, well, it does seek permanent custody, which is really, in my view, issues to be heard by Judge Heydrich.
Sir, I just want to make sure that you understand the state of everybody's agreement, which is on this day and the whole week prior. My understanding, Mr. George's understanding, and my son's understanding was that he was under the supervision of his father during this time. Now, like I said, he's 17. He goes to the house that he wants to go to. Okay, I don't put any restrictions on any of that, but I just want to make it clear that it was with the intention and understanding of all parties involved that Mr. George had supervision of my son. If I was not confident in that, sir, my son would be with me. And that's why I was going through what state and condition I turned my son over to Mr. George. I understand we're dealing with what happened Friday. I am also dealing with that same thing. I'm trying to let the court, Your Honor, understand that everybody involved was under the impression and knew that my son was under the supervision of Mr. George.
To me, madam, I'm trying to communicate that's wholly irrelevant. What I'm here dealing with is, should I change primary physical custody because of the alleged beating of your 17-year-old by your older son? That's what I'm here to decide.
And Your Honor, if I may,
Ms. Counsel, I'll hear from you.
Your Honor, if I may just highlight 2 points. One, we are here because of the best interests of the child. The child was not being supervised and he was beaten up, had blood, a swollen eye. His father had to take him to the emergency room the next day for treatment. A gun was also pulled out on him. Now, I understand Miss Abdullah was in Colorado during this time period, and that's why we're here. Because while she indicates that her understanding was that the child was to be with the father, the documents indicate differently. And the child was at a home that is her residence with the 24-year-old. It's not like the child was at my client's residence during this happened, during his custody and control. This is during the time period that has been outlined in the order by the courts. That is Miss Abdullah's parenting time. And I know we have indicated that it is just one time that the police had to come out. But we look at the state of affairs in our world now. We don't want it to be a second or third time that the police have to come out because a gun was pulled on a 17-year-old. We don't want a second or third time that a 17-year-old has to be rushed to the emergency room because he has blood on his hands and a swollen eye.
Are both boys living with Mr. George?
Both boys live in a residence. Both boys were located in a residence that was under Miss Abdullah's control. So while Miss Abdullah is way on the West Coast in Colorado, a 17-year-old is being supervised, quote unquote, by a 24-year-old.
Okay.
And getting into a fight with the 24-year-old.
But Mr. George is not present while these two boys are in the residence of Ms. Abdullah. Ms. Abdullah.
No. Because it's her parenting time.
Miss Abdullah's residence. She's in Colorado. The boys are in the residence of Ms. Abdullah, and Mr. George is someplace else, but here in Atlanta.
Yes, and
So
we would like for him.
The two boys are without supervision.
The two boys are without supervision. Just for added clarification, the 24-year-old is the 17-year-old stepbrother. So the 17-year-old is the child of the relationship that Miss Abdullah and Mr. George had as a married couple. The 24-year-old is a child that Miss Abdullah had prior to the two parties getting married. But we have a 24-year-old offering supervision for a 17-year-old while mom is hours away. And that is the problem here, because now the 24-year-old who's supposed to be supervising the 17-year-old, they're now fighting.
All right. So, and Mr. George is employed, and thus he couldn't supervise either child either, because he's not.
Mr. George is capable of supervising. It wasn't his parenting time. His regular parenting time is the first and third.
Is Mr. George capable of supervising, or does he work?
He does work, but he is capable of supervising, Your Honor.
That's not the answer to my question. If Mr. George is not in the house and the boys are in the house, thus Mr. George is not supervising.
Mr. George is not supervising. We're asking that the 17-year-old be allowed to reside with Mr. George for this temporary.
George is not there to give him any supervision either.
It's not Mr. George's parenting time. Mr. George is in Atlanta.
That's my point. You're asking for some remedy for the 17-year-old. I'm trying to find a remedy. Excuse me.
I'm sorry.
Where the 17-year-old will be supervised. Mr. George works. The 17-year-old, I don't know, does he go to school? What does he do?
He does. The 17-year-old goes to school, and what we were proposing for a remedy.
How come nobody will let me finish my statement?
My apologies, Your Honor.
When I'm talking, is it not possible just everybody hold off and give me a chance to finish my thought process? My thought process is that the child, the 17-year-old, he's in school. Mr. George is working somewhere. Probably they can be together on weekends, and thus the young 17-year-old could get some modicum of supervision. But during the ordinary traditional day, the 17-year-old doesn't have any supervision. We don't know if he goes to school or not. What if he doesn't go to school? What if he's out on the street with his 17-year-old friends? Don't know this. I'm trying to find out what to do with the 17-year-old where this event will not happen between the 17-year-old and the older brother. I'm trying to find a place for him. Have you got a place for him?
I do, Your Honor. What I propose is that the 17-year-old live with his father in Atlanta. His father will ensure that he attends school timely. His father has already been in close contact with the private school that he attends. And the father will be the temporary primary physical custodian until Judge Hydra issues another order regarding the same.
Your Honor, he already is supervising the child and is not doing those things now. So what difference does it make? What difference does it make? And if he thought this was in such an emergency,
Well, what is your recommendation we do with the younger child?
my son would like to be home Monday through Friday so he can go to school and spend weekends with his father. That's what he has told
Where
me.
is home?
At my home.
But you're not there.
I am not there.
Well, then why is that better for the 17-year-old?
Because Mr. George, when he is staying at one time, Mr. George, he was staying with Mr. George for 10 days. Even though Mr. George gave him a car and he didn't have a license, he still was having to pay for the gas going back and forth. And it was a 45-minute drive on the highway for my son every day to get to school. From my home, it's 10 minutes. Mr. George was complaining about how much gas that he would have to send him $20, $25 worth of gas every day. And so we came up with, he would spend it at my home 5 days and at his father's on the weekends. But we didn't do that either. He started spending time with his father more. I'm trying to figure out which one does the attorney want to go with. Because on one piece of paper, he's saying that he has his son 95% of the time. And now they're saying that I'm not supervising. I just don't understand which one it is.
All right. Anything else?
It just seems as if he's trying to put the responsibility on me, whether my son is with me or not. And he doesn't want to take accountability and responsibility for my son when he's with him or not. That night, Mr. George took 3 hours to get there. By the time Mr. George got there.
I don't want to plow this field over and over. Let me deal with the issue before me. The issue before me is what to do with a 17-year-old who's been violently attacked by an older sibling.
Your Honor, I have a private school here that is comparable to the one that he has. He can come to Denver and stay with me. It's obviously that Mr. George doesn't think that he is good with my brother, even though this was a brother spat. Both of them had injuries. This was a brother spat that was started by my youngest son.
Here's the 17-year-old now as we speak.
The 17-year-old after the incident was, no, the 17-year-old after the incident spent 4 days with one of my—
Where is the 17-year-old right now as we speak?
Hold on, I can tell you.
Your Honor, it is my understanding that after the incident, and my client went over to check on his son, that his son has been with him.
No, that is not correct.
The incident.
That is not correct. He was at Mohamedu's house for 4 days. He just got to Mr. George's house. Yesterday was Christmas, the Christmas Eve that evening. And currently, Your Honor,
he is the son right now.
He is in Mr. George's house right now.
I'm in the middle of a sentence.
He's in Mr. George's house.
I do not want to be interrupted while I'm in the middle of a sentence.
Oh, I thought you wanted me to answer. I'm sorry.
My question is, where is the son?
He's in Mr. George's house.
I do not want to be interrupted while I'm speaking. Okay. Where is the son now as we speak, in case I want to talk to the son?
He's in Mr. George's house right now. He has the bedroom in the basement.
I don't care where part of the house he is. Does he have access to communicating with the court?
Yes, sir. I told him to be on standby.
All right. Sarah, are you there?
Yes, Judge.
Is there a way for me to communicate with the 17-year-old in a, what do we call it when we send people out of court? What's the,
breakout room, Judge?
Yeah, what did you call it?
A breakout room. So if the minor child has a cell phone, he could actually just, from wherever he is in the home, log into this call and we can put y'all in a separate room to speak.
I want to have a private, brief conversation with the 17-year-old. I do not know how to accomplish it. I'm electrically technologically incompetent. So if you can arrange that.
Your Honor, I can have him to sign into the link that was sent to me, and then they can put them in the breakout room from there.
Right. Whatever it takes. I'm not competent to do it. So, Sierra, can we?
Give us a few minutes, Judge.
Yes, ma'am.